Hello, the current session of environmental law is on National Green Tribunal. Now we will talk about the jurisdiction part of National Green Tribunal, where we will be essentially discussing about Section 14 and 16 and Section 29. When we talk about, so there are basically two kinds of jurisdiction: original and appellate. So Section 14 is about the original jurisdiction, where it talks about the settlement of disputes, and 16 is about the appellate jurisdiction, and 29 essentially talks about the a bar of jurisdiction. So if we look at section 14, subsection 1 says that the tribunal shall have the jurisdiction over all civil cases where a substantial question relating to environment, including enforcement of any legal right relating to environment, is involved, and such question arises out of the implementation of the enactment specified in schedule 1. Subsection 2 says that the tribunal shall hear the disputes arising from the questions referred in subsection 1 and settle such disputes and pass order thereon. Subsection 3 of section 14 says no application for adjudication of dispute under this section shall be entertained by the tribunal unless it is made within a period of 6 months from the date on which the cause of action for such dispute first arose. And the proviso says that the tribunal may, if it is satisfied that the applicant was prevented by sufficient cause from filing the application within the set period, will be allowed it to be filed within a period not exceeding 60 days. Now when we look at the legal provisions given under 14, it says that the substantial question relating to environment must be involved. So there is a limitation that we see, and the question must arise out of implementation of 7 legislations that particularly that is given, which is mentioned under schedule 1 to the act of 2010. Now schedule 1 uh, of the act, it talks about the following legislation like water prevention control of pollution act of 74, water prevention control and pollution cess act of 1977, forest conservation act of 1980, air prevention and control of pollution act of 1981, environmental protection act of 1986, public liability insurance act of 1991, and Biological Diversity Act of 2002. And if we look at section 16, it deals with the appellate jurisdiction of the tribunal. So it provides that where any person is aggrieved by any decision, order, or decision of the various authorities above which is mentioned, we have just discussed, and then keeping the public liability insurance out of the jurisdiction, talks about only 6, and keeping this Public Liability Insurance Act out of the jurisdiction on or after the commencement of the act, then he may appeal before the tribunal. Now, the limitation period, when we look into the provision in for both the jurisdiction, the limitation period is different. In the case of original jurisdiction, it is 6 months from the date on which the cause of action arose, and a grace period is given, that is of 60 days. That also when the tribunal thinks, that is of the opinion that it's a case of sufficient cause. And when you look at section 16 and you interpret the provision, it says that in case of appellate jurisdiction, it is 30 days from the date of communication of direction, order, or decision of the party. However, grace period of 60 days is given in case of sufficient cause. Okay, so now here when we look at the provisions, it talks about that essentially substantive question. Now let's look at the section 29, which talks about the bar of jurisdiction. Now when you look at section 29, and you have which says that the section 29 of the act provides the it bars the jurisdiction of any civil court to entertain an appeal in respect of any matter which falls within the appellate jurisdiction of the tribunal. Now, with effect from the date of establishment of tribunal under this act, no civil court shall have the jurisdiction to entertain any appeal in respect of any matter which the tribunal is now empowered to determine under its appellate jurisdiction. Okay. So now subsection 2 says that no civil court will have the jurisdiction to settle dispute or entertain any question relating to any claim for granting any relief or compensation or restitution of property damaged or environmental damage which may be adjudicated upon by the tribunal. So wherever the tribunal has a jurisdiction, no civil court can take the matter up, and no injunction in respect of any action taken or to be taken by or before the tribunal in respect of the settlement of such dispute or any such claim for granting any relief or compensation or restitution of property damaged or environmental damage shall be granted by any civil court. Now, the successful establishment of NGT actually encouraged Supreme Court of India to review its PIL environmental, caseload, and its limited environmental expertise. And in 2012, a very important in a PIL case, Supreme Court of India, transferred all the environmental cases, both active and prospective, to the NGT to render, to solve the matters in more expeditious and specialized judgments, and to avoid the likelihood of conflicts of order between High Court and NGT. And this case was Bhopal Gas Pidit Mahila Udyog Sangathan versus Union of India. Now, it was a case of 2012. So now when this thing happened, so it's basically where the Supreme Court in this regard stated that keeping in view the provision and scheme of NGT Act of 2010, particularly section 14, 29, 30, and 38 subsection section 38 subsection 5, it can safely to be concluded that the environmental issues and matters covered under NGT Act Schedule 1 should be instituted and litigated before the National Green Tribunal. Okay, and such approach may be necessary to avoid likelihood of any conflict of orders between the high courts and NGT. And thus they have directed that all the matters instituted after coming into force of the NGT Act and which are covered under the provisions of NGT Act or in Schedule 1 to the NGT Act shall stand transferred and can be instituted only before the National Green Tribunal from now onward. Thus, it will help in rendering expeditious and specialized justice in the field of environment to all the concerned. Now we look into the legal provisions which deals with procedures and power of the tribunal. That is section 19, which says that the section 19 of the act lays down the procedures and power of the tribunal. It's very important from the perspective of your syllabus also. It provides that the tribunal shall not be bound by procedures laid down by Code of Civil Procedure 1908, but shall be guided by the principle of natural justice. It further provides that the subject to the provision of the Act, the tribunal shall have powers to regulate its own procedure. Now, this is a very important power. It also provides that the tribunal shall not be bound by the rules of evidence contained in the Indian Evidence Act of 1872 while discharging its functions, and that the tribunal shall have the same powers as are vested in civil court under Code of Civil Procedure while trying any suit. It also provides that all the proceeding before the tribunal shall be deemed to be judicial proceedings within the meaning of section 193, 219 and 228 for the process of section 196 of Indian Penal Code, and that the tribunal shall be deemed to be a civil court for the purposes of section 195 and chapter 26 of the Code of Criminal Procedure 1973. Okay, all of it is given under, so you have to interpret your section 19 in order properly in order to understand the what are the powers and the procedure that is being given under the National Green Tribunal Act. Now we look into the provisions which talks about the relief, compensation, restitution that is given under section 15, and then we will be discussing about application or appeal which can be forwarded, can be applied into the in the tribunal, that is section 18, and then parts of section 20 also, which deals with the tribunal to apply certain principles, and then section 22 which allow you which is about the which talks about the legal provisions which is about appeal to Supreme Court of India. So when you look at section 15, it essentially talks about the procedures, legal provisions which is related to relief, compensation and restitution. Subsection 1 says that the tribunal may by an order provide, clause A says relief and compensation to the victims of pollution and other environmental damage arising under the enactment specified in the Schedule 1. Okay, and it is also including the accident occurring while handling any hazardous substance. And then clause B says for restitution of property damage. C says that for the restitution of the environment for such area or areas as the tribunal may think fit. Subsection 2 says that the relief and compensation and restitution of property and environment referred to in clause A, B, C of subsection 1 shall be in addition to the relief paid or payable under the Public Liability Insurance Act of 1991. Subsection 3 says no application for grant of any compensation, relief, or restitution of property or environment under this section shall be entertained by the tribunal unless it is made within a period of 5 years from the date on which the cause for such compensation or relief first arose. So it talks about the limitation period of 5 years. And the proviso says that the tribunal may, if it is satisfied that the applicant was prevented by sufficient cause from filing the application within the said period, allow it to be filed within a period not exceeding 60 days. Again, the grace period it also provides, that is the period of 60 days. Okay, but the question is that the tribunal may, if they are satisfied, then only it will be allowed. Now, subsection 4 says that the tribunal may, having regard to the damage to public health, property, and environment, divide the compensation or relief payable under separate heads specified in Schedule 2. So, as to provide compensation or relief to the claimants and for restitution of damage of property or environment as it may think fit. So now may means here it's not obligatory for them to do. Okay. Now subsection 5, every claimant of the compensation or relief under this act shall intimate to the tribunal about the application filed. They must convey this to the tribunal about the application that it has been filed to, or as the case may be, compensation or relief received from any other court or authority. They must convey this thing to the tribunal. Okay, now then we will look at section 18, which talks about the application or appeal to tribunal. Now subsection 1 talks about each application under section 14 and 15 or an appeal under section 16 shall be made to the tribunal in such form, contain such particulars as, and be accompanied by such document and such fees as may be prescribed. Subsection 2 says that without prejudice to the provisions contained in section 16, an application for grant of relief or compensation or settlement of dispute may be made to the tribunal by, subclause A says, the person who has sustained the injury or the owner of the property to which the damage has been caused, or whether death has resulted from the environmental damage by all or any of the legal representatives of the deceased, or Any agent duly authorized by such person or owner of such property, or all or any of the legal representatives of the deceased. As the case may be, any person aggrieved, including any representative body or organization, or the central government or state government or union territory administration, or the Central Pollution Control Board, or a state pollution control board, or pollution control committee, or a local authority, or any environmental authority constituted or established under the Environmental Protection Act of 1986, or any other law for the time being in force. And the proviso says that where all the legal representatives of the deceased, the one who's dead, have not joined in any such application for compensation. What if none of them have filed any compensation application? Now, or relief or settlement of dispute, the application shall be made on behalf of or for the benefit of all the legal representatives of the deceased, and the legal representatives who have not so joined shall be pleaded as respondents to the application. Now, provided further that the person, the owner, the legal representative, agent, representative body, or organization shall not be entitled to make an application for grant of relief or compensation or settlement of dispute if such person, that the owner, the legal representative, agent, representative body, or organization, have preferred an appeal under section 16. Okay, that we have already discussed the appellate under appellate jurisdiction. Now subsection 3 says that the application, or as the case may be, the appeal filed before the tribunal under this act shall be dealt with by it as expeditiously as possible. An endeavor shall be made by it to dispose of the application. Remember, the objective of the act is that. Okay, and as the case may be, the appeal finally within 6 months. So this is the period from the date of filing of application, or as the case may be, the appeal after providing the parties concerned an opportunity to be heard. So it has to be heard, okay, and finally decided in during this duration, the time that is given in here. Now, when we look at the whole procedure, we get to know about that. Okay, in what manner, what procedure, what timeline, within what is the limitation period for seeking relief, and what are the conditions, who all can file for an for the appeal, who can file for application for compensation, and what is the procedure to appeal in front of the Supreme Court. So these provisions are the core and very, very important provisions of the National Green Tribunal. Now we look into chapter 4, which talks about the most important part, that is the penalty. Section 26, 27, 28 we shall be looking into. 26, it talks about the penalty for failure to comply with the orders of National Green Tribunal, and 27 is about offences when it's committed by the companies, and 28 is about what provisions which are there where offences are being committed by the governmental department. So section 26 sub clause 1 says that whoever fails to comply with any order or award or decision of the tribunal under this act, he shall be punishable with the imprisonment of a term which may extend to 3 years, or fine which may extend to 10 crore rupees, or with both, and in the case of failure or contravention continues, with additional fine which may extend to 25,000 for every day during which such failure or contravention continues after conviction for the first of such failure or contravention. Now, the proviso says that in a case of company fails to comply with any order or award or decision of the tribunal under this act, such company shall be punishable with fine which may extend to 25 crore rupees, and in case of failure of contravention continues, with additional fine which may extend to 1 lakh rupee for every day during which such failure or contravention continues after the conviction for the first such failure or contravention. Now, subsection 2 says that notwithstanding anything contained in the code of CRPC, that is Criminal Procedure Code, and every offense under this act shall be deemed to be a non-cognizable offense within the meaning of the said code. Okay. Now, when we look at section 27 and 28, 27 is about when offences are committed by companies. Subsection 1 says where any offence under this act has been committed by a company, every person who at the time of offence was committed was directly in charge and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly, provided that the nothing contained in the subsection shall render any such person liable to be punished. Okay, under this act, if he is able to prove that the offense was committed without his knowledge or that he had exercised all the due diligence to prevent the commission of such offense. Okay, this is something that we have already been discussing in specific acts when I have taught you that. Subsection 2 talks about notwithstanding anything contained in subsection 1, when an offense under this act has been committed by a company, it is proved that the offense has been committed with the consent of, or or it attributable or to any neglect on the part of any director, manager, secretary, or other officer of the company. Such director, manager, secretary, or other officer shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Okay. Now the for this the purpose, the explanation says that the company means any body corporate includes a firm or other association of individuals, and director would be in relation to a firm means a also means a partner in the firm. Okay. Now section 28, which talks about the offenses when it is being committed by the governmental department. Now subsection 1 says where any department of the government fails to comply with any order or award or decision of the National Green Tribunal, the head of the department shall be deemed to be guilty of such failure and shall be liable to be proceeded against for having committed an offense under this act and shall be punished accordingly. And okay, but the proviso says that nothing contained in this section shall render such head of the department liable to any punishment if he is able to prove that the offense was committed without his knowledge and that he has applied all his due diligence to prevent the commission of such offense. Okay, now subsection 2 says that notwithstanding anything contained in subsection 1, where an offense under this act has been committed by a department of government and it is proved that the offense has been committed with the consent of the consent of or it is attributable to any neglect on the part of the officer or the head of the department, such officers shall be deemed to be guilty of that offense and shall be liable to be proceeded against and punished accordingly. Okay, now we will talk about section 30, which is given in the chapter 5, which talks about the cognizance of offences. Subsection 1 says that no court shall take cognizance of any offence under this act except on a complaint made by the clause A says that the central government or any authority or officer authorized in this behalf by that government, or clause B says any person who has given notice for not less than 60 days in which a manner as may be prescribed of the alleged offence of his intention to make a complaint to the central government or to the authority or officer authorized as aforesaid. Subsection 2 says that no court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall try any offence punishable under this act. Now, in relation to this, I have already discussed with you all the provisions given under section 29, which talks about bar or jurisdiction. So together you can deal with both of them. Now we look into some of the important cases which were decided judgment of National Green Tribunal. First one is Aditya N. Prasad versus Union of India. Now a modified appeal. Here what happened? The applicant Aditya filed an application under section 18, subclause A, read with section 14, 15, and 17 of National Green Tribunal Act, praying for various reliefs in relation to the environmental issues, primarily relating to the trees, their maintenance in accordance with the provisions of the Act. Now, the tribunal, via its order dated 23rd April 2013, had directed that the concerned authority should deconterize the trees all over in city of Delhi, national capital territory of Delhi. And thereafter another application was filed with the prayer that the concretization of deconcretization was being done in a manner which was further damaging the trees rather than providing them with a life. And it was stated that the deconcretization work are being done recklessly by persons not fully skilled in that behalf, and this was resulting into serious damage rather to the roots of the trees. And then tribunal again passed an order in 2013, and directed that the authorities should ensure that the damage done to the trees, which was shown in the photographs, some photographs were presented, so the same would be cured and damage would not occur, forthwith in future. And the person operating any machines for deconcretization shall ensure that no damage is caused to the trees and the roots are not left exposed. And even after passing of the above order, it was reportedly reported that the wide number of trees were being damaged because of the irresponsible and indiscriminate use of the machines by, again, unskilled persons, and the trees were being felled, and thus there was a violation of the orders of passed by the tribunal. So an application was filed under section 26 of National Green Tribunal Act of 2013, praying for initiation of action for contempt against the respondent for consequent punishment in accordance with law. And the main question before the NGT was whether there was contempt of order of tribunal or not. So the decision, it was held that the MCD has failed to discharge its statutory function in accordance with law, and also has flouted the orders of the tribunal as it established by the affidavit of the Forest Department. And they have held that it is not a case of civil imprisonment for violating the order of tribunal. However, in exercise of power vested under Section 28 read with 15 of NGT Act, they have directed and imposed cost of rupees 50,000 as compensation, which was to be paid by the corporation at first instance for causing damage to the trees and environment. However, the said cost shall be, it was also further stated that the said cost shall be recovered from all the officers most senior to most junior involved in the process of deconcretization of the trees in CR Park in proportion to their responsibility. Furthermore, it was further directed that the South MCD to do the compensatory afforestation by planting 20 trees in ratio of 1 is to 10 for each fallen trees in CR Park, and to file its proof on record. And it was further directed that in future the deconcretization will be done in consultation with the horticulture department of the concerned authority, and wherever it will be necessary. Now the next case that we'll now look into is case of Sarang Yadvadkar versus Pune Municipal Corporation. So what happened in this case? The tribunal, National Green Tribunal, allowed the construction of a road within a floodplain, but subject to stringent condition. Now, the tribunal ordered that the construction of the road on elevated pillars in the areas of the floodplain, irrespective of the additional cost, and would neither obstruct the flow of the river and nor allow the floodplain. So not, it's not even going to obstruct the flow of the river, not it gonna narrow the floodplain. So the scientific evidence supports this argument, and that even a slight encroachment on a floodplain can impair the hydrological function, including groundwater recharge, biological productivity, sediment trapping, and stabilization habitat for flora and fauna, and nutrient storage of the floodplain ecosystem, which can further create problem for present and future generation. And then we see that, however, in Om Dat Singh, which is a state of UP case, it's case of 2013, 2015. So in this case, what happened? NGT gave its go ahead nod to the Kanhar, irrigation project in Sonbhadra district, primarily on the ground that a lot of investment had gone into already. So it further directed that a committee with Principal Chief Conservator of Forest Uttar Pradesh as its convener be set up, which will report to it to look into the aspects related to ecology and biodiversity, environment and rehabilitation and resettlement policy. And it looked that the NGT tried to pass an equitable order in this case of Om Dat Singh. And when we look into the case of Saloni, you can also look into some case of Saloni Singh versus Union of India. It's a case of 2014 where it was submitted by the applicant side that the railway authorities have failed to perform their statutory duty and that they are indirectly responsible for causing pollution on the railway properties and particularly on the railway tracks. And it was further contended that in the view of the Indian railways, penalties for activity affecting cleanliness at railway premises rule 2012, the railway authorities are expected to perform their functions to maintain hygiene and clean environment. Now white and white powers which enable them to appoint officers armed with the punitive powers to collect fines and in accordance with these rules have also been vested on them. Now the principal bench of NGT, National Green Tribunal, was of the consideration, it was of the view that the railway authorities are expected to perform their statutory duty in terms of the rules of 2012 as well as discharge their obligatory function under the provision of Environmental Protection Act of 86. And further it was ruled out by NGT that every conceivable human act contributing to pollution on railway tracks or on railway property is objectionable, and it directed the zonal manager of all the railway zones to immediately issue a circular and start collecting fines from the offenders in accordance with the rule of 2012, besides taking appropriate action in terms of Environmental Protection Act of 1986, as collection of penalty not exceeding rupees 500 is for the act or offence committed by an individual. It was also ruled that the such punishment, however, does not absolve the offender from obligation of paying compensation on the basis of polluter pays principle. Okay, so now it further directed that any person who's found to be committing any of the above offenses and polluting the environment, creating public nuisance, which obviously is creating, which can further create health hazard, to the public at large, would be liable to pay at least sum of 5,000 rupees or such other amount as would be would be determined by the tribunal upon notice to him in accordance with the law on polluter pays principle. And the railway authority was further directed to educate people in relation to the proposed action and for and through variety of means, and the education program undertaken by railway was to include due publicity of the rules also of 2012. Now the next case of Manoj Mishra, which is Union of India. It's a case of 2013, where the principal bench of National Green Tribunal directed the National Green, NCT of Delhi, National Capital Territory of Delhi, and all public authority cooperation to ensure that the debris at the river bank of Yamuna are removed immediately, as well as no further debris are permitted to be dumped under any circumstances. And it further directed the National Capital Territory of Delhi to post police to even prevent dumping of debris, and Home Secretary of Delhi to ensure that posting of police guards towards river bank of Gita colony at all openings, and the warning boards which have been broken and thrown on the roadside should be erected properly. And the tribunal has also ordered that the government agencies responsible for cleaning the Yamuna in Delhi to meet immediately and prepare a beautification plan, or else they all have to pay exemplary cost from the salaries of their respective officers. And it was said that the beautification plan of Yamuna should be prepared in a way
so that the river bank is protected from the menace of dumping of garbage and debris or any other material, with specific attention of the Committee to the Protection of Floodplain Area. By its order dated July 2013, the principal bench of National Green Tribunal, because of the reason that there has been persistent pollution going on, obstruction on the river bank of Yamuna by dumping of debris, directed to invoke the principle of polluter pays, and directed that any person who's going to be found dumping debris in Yamuna, in the Gita colony site, for that matter, in any site, shall be, liable to pay a sum of 5 lakhs for causing pollution as well as for removal of debris from the site in question. Now, when we look at the all the decisions, you find that how well, what kind of role, how effective and expeditious manner NGT is playing its part in protecting and safeguarding the environment. Now, finally, when we conclude the importance and how remarkable, different aspects of establishment of NGT are, we can say that it was not just a reform, it was a beginning. It marked a beginning for India's struggle between environment and development. It was a new ray of hope for environmental movement in India, as it in fact it was Supreme Court of India had itself demanded its creation through different judgments, landmark judgments. And NGT is a statutory manifestation of judicial prescription. However, it has loopholes. It is not free from drawbacks. Like, scholars have argued that the non judicial members' qualifications should be reframed, that only highly eminent experts with micro specialization are appointed rather than making mediocratic or bureaucratic justice. Also, due to geographic and structural limitation perpetuated by political apathy, the NGT has been struggling, and a relatively centralized and specialized court is a misfit for a vast country due to its inaccessibility to the majority of people. Then we talk about that the opaque, the kind of practices NGT adopted, um, the practices of Indian judiciary in the matters of appointment, like NGT Act laid down only the qualification of the chairman, judicial member, and technical member, and does not elaborate on methods of their appointment. Section 6 states that the chairman shall be appointed by the central government in consultation with Chief Justice, and the judicial and technical members shall be appointed on the recommendation of the selection committee. And consultation and recommendation need not necessarily lead to a selection of a meritorious candidate. Also, when we look into the process of setting up of the specialized court, we fail to preserve the virtues of the existing system. So NGT has its headquarters in Delhi and four regional benches as Bhopal, Kolkata, Pune, and Chennai. It is structurally and functionally, thus a very inadequate to satisfy people's need in a country like India, which has vast problem, huge, issues. Uh, and due to lack of access, there are thousands of grievances, related to environmental issue, which actually doesn't reach the adjudicatory mechanism at all. And um, the NGT is ordained by law to follow the international environmental principle of sustainable development, precautionary principle, and polluter based principle. However, nowhere in the statute these principles have been defined. So it again put up onus on the judges to interpret these principles. And overall, the NGT Act 2010 is a landmark, legislation, and it can be viewed that the NGT is proved as a creation of a very significant and a very positive development that has happened, despite of its defects. It is still proved to be a has proved to be a very effective mechanism, effective tool in handling cases of environment and protecting the environment, with the help of National Green Tribunal. while solving the matters related to environmental issues.